Hi, I'm Rebecca Ellis with the Project on Predatory Student Lending, and in this video, I'm going to be talking about the preliminary settlement in the Sweet v. Cardona case. Those of you who've been following the Sweet litigation for a number of years now will know that this settlement represents a hard-fought victory on behalf of hundreds of thousands of defrauded federal student loan borrowers. In this video, I'm going to explain what the settlement means and how it will affect your borrower defense application. So first of all, what does it mean to settle this case? If the settlement agreement between the plaintiffs and the Department of Education gets final approval from the court, then the department is going to resolve all pending borrower defense applications according to the procedures that I'm going to explain in this video. And at that point, the litigation will be over. So exactly which procedures apply to you will depend on whether you're a member of the settlement class. For purposes of this settlement, the class includes everyone who applied for borrower defense on or before June 22nd, 2022, and hasn't yet received an approval of their borrower defense application. Now, if you applied after June 22nd, 2022, or if you do apply between now and when the settlement becomes final, then you will not be a member of the settlement class, but you will be a post-class applicant, and there are some provisions of the settlement that will affect your application. To give you a sense of the scope of this settlement agreement, the settlement class consists of about 264,000 people who together received about $7.5 billion in federal student loan disbursements. The settlement class is divided into two groups, the automatic discharge group and the decision group. And in this video, I'll be explaining who fits into which category and what you can expect. I'll also be explaining what post-class applicants can expect to happen to their applications. But just to take a step back for a moment, how did we get to this point? Well, the Project on Predatory Student Lending filed the Sweet case in June 2019. At that point, the Department of Education had refused to decide a single borrower defense application for over a year. In the course of the litigation, the parties reached a first proposed settlement. But as many of you know, what happened then is that the Department of Education, under Betsy DeVos, started sending out tens of thousands of form denial notices, which didn't provide any reasonable explanation for why these applications were denied. In October 2020, the court rejected that first proposed settlement, finding that the department had acted in bad faith, and the litigation continued. At that point, the plaintiffs were able to get documents from the department. We were able to depose certain high-ranking department officials. And in March 2021, we filed a supplemental complaint explaining that it wasn't just delay that was the problem. It was that the borrower defense process had been rigged against borrowers. When a new administration took over the Department of Education, the parties began exploring whether they could reach an agreement on a settlement in this case. And on June 22nd, 2022, we filed a joint motion with the court for preliminary approval of a new settlement agreement. On August 4th, the judge granted preliminary approval, and that's where we find ourselves today. Now I'm going to talk in a little more detail about those settlement groups that I mentioned and who falls into which category. I know that the biggest question most of you have is what is going to happen to your borrower defense application? And that will depend on where you find yourself in this flowchart. It might be useful to pause the video at this point, and if you answer some of these simple questions, you can see which of the settlement groups you fall into. I know many of you will also be wondering, what about the applications that were previously denied under Secretary DeVos's form denial notices? I have good news on that. All of the form denial notices are going to be rescinded under the settlement. That means it will be as if those denials that happened between December 2019 and October 2020 never happened. Your original borrower defense application will be reinstated. You don't have to reapply. You don't have to take any other steps. The first group I'm going to cover here is the automatic discharge group. So this consists of class members, that is people who applied for borrower defense on or before June 22nd, 2022, who borrowed to attend a school that's on a list attached to the settlement agreement. A link to that list is in the video description. This list consists of schools that the Department of Education has found at this point have strong indicia of widespread misconduct. If your application relates to one of those schools and you're a class member, then all of your federal student loans from that school will be fully discharged. You'll also receive refunds of any amounts that you previously paid to the department on those loans, and those loans will be deleted from your credit report. If you're a class member whose application relates to a school that is not on the list attached to the agreement, then that means that you'll be in the decision group. The decision group will receive individual decisions on their borrower defense applications according to a timeline that's scaled to how long ago you applied. So the longer you've been waiting, the sooner you're going to get a decision. The department will also be using what we've called streamlined procedures to decide these decision group applications. That means, for example, that no decision group application will be denied for so-called insufficient evidence. If you do not get a decision within the timeline that applies to your application, then you're going to get full settlement relief, which is to say the same as the automatic discharge group. Discharge of all of your applicable loans, refunds of amounts already paid to the government, and deletion of the loans from your credit report. Anyone who applied for borrower defense after June 22, 2022, or who does apply before the settlement agreement becomes final, will be a post-class applicant. Post-class applicants are going to receive decisions on their applications within 36 months after the final effective date of the settlement. So that's essentially just a little bit longer than the people at the tail end of the decision group. The main difference for post-class applicants is that if you attended a school that's on the list attached to the settlement, you will not automatically receive relief. You will still get an individual decision on your application. Your application will also not be decided under the streamlined procedures. They'll be decided under standard borrower defense procedures. But you are guaranteed that decision within 36 months after the settlement's effective date, or else you also will receive full settlement relief. Now, it's still possible to apply for borrower defense after the final approval date of the settlement. But at that point, your application will not be governed by any of the provisions in the settlement. It will just be whatever the borrower defense regulations are that are in place at the time. So now I'm going to talk about what are the next steps for each group. And in this chart, you can see a depiction of when you can expect action on your borrower defense application. I'll go into a little more detail on this in the next few slides. For the automatic discharge group, good news, you're done. You don't have to do anything else. You will receive relief within 12 months of the final effective date of the agreement. If you're in the decision group, then you still don't have to do anything right now, but the next steps could potentially be a little more complicated. If your application is approved within the set timeline, then you'll receive full settlement relief. That's simple. If your application is not approved on this initial evaluation, then you'll receive what's known as a revise and resubmit notice. This will be a notice from the department that explains what was missing from your application and what you can do to improve your chances of having your application approved. You'll then have 6 months from receiving that notice to submit a revised application to the department. And the department will then have another 6 months to make a final decision on that revised application. If you decide not to resubmit after receiving the revise and resubmit notice, then after the 6-month period, that notice will convert into a final denial. Now, it's important to note that if your borrower defense application is denied, either after you resubmit or by the conversion of your revise and resubmit notice, then you do have the right to challenge that denial in court to say either that the department made a mistake on the merits of your application or that they didn't provide a sufficient explanation of why it was denied. If you're a post-class applicant, as I've said, the department will issue an individual decision on your application within 36 months of the effective date. What you get within that time will be either an approval or a denial. Postclass applicants will not get revise and resubmit notices. But just like the decision group, you will have the right to challenge any denial in court. While you wait, the department has committed to hold class members in forbearance or stopped collection status with zero interest, either until you receive your relief under the settlement or until a final denial decision occurs. Another important thing to know is that class members and post-class applicants do not have to consolidate their loans or take any other steps to receive their full relief. So if you have federal family education loans, you do not have to take any steps now to consolidate into direct loans. The department has agreed to take all steps necessary to make sure that FFEL borrowers get their full relief. Finally, what's next in this litigation? Because the court has granted preliminary approval, that means that right now we're in a period where class members can submit comments to the court, either in support of the settlement or to express disagreement with the settlement. That comment period is going to last until September 15th. And in the video description, you can find a link to our website with information on how to submit those comments, either by postal mail or by email. The fairness hearing on the agreement, also known as the final approval hearing, is currently scheduled for November 3rd, 2022 at 11 a.m. Pacific time. That's where the parties will present their final arguments to the court for why the agreement should become final. When we receive details about how class members or members of the public can virtually attend that hearing, we'll be posting them on our website. After that hearing, if the court does grant final approval, there will be a 30-day period for that judgment to become final. After those 30 days, the department will begin issuing relief to the automatic discharge group, and the clock will begin to run on the timelines for the decision group. On the other hand, if for some reason final approval is denied, then the case will return to litigation at the point where it left off. You can learn more about the sweet settlement and about the other work that the Project on Predatory Student Lending does for defrauded student loan borrowers at our website, www.ppsl.org. You can also follow us on Twitter for the latest updates @EdDebtJustice. Thank you for watching.